Hello and welcome back. I'm attorney Andrew Bethel. An extremely common and totally understandable question I get as an estate planning attorney is, why do I have to come back and do a whole amendment to make a change? Can't I just handwrite it? Today we're going to talk about a case that teaches us the importance of properly amending a trust and how a post-it note, spoiler alert, just won't do the trick. So grab your popcorn, it's story time. But first, thank you so much for watching. If you find this video helpful, please hit the like button, and if you want to see more, please subscribe and ring the bell, or drop a comment below. Our story begins with a man named Anderson, who created a trust in 2004. Trusts are like cooking instructions. They need clear instructions, otherwise your beautiful cake might come out a little lumpy. Anderson's trust had a specific requirement for amendments. They had to be made by a written instrument signed by the settlor, that's Anderson, and delivered to the trustee. Now this is where things get sticky. In 2014, Anderson wanted to amend his trust. He made some handwritten changes, crossed out beneficiaries, added new ones in, and changed distribution percentages. Then he attached a post-it note that said, "Hi Scott, here they are. First one is 2004, second is 2008. Enjoy, best, Rob." Unfortunately, Anderson passed away before he could sign a formal amendment. So the court had to decide, were the interlineations and the post-it note enough to amend the trust? Spoiler alert, they weren't. Under California law, a trust can be revoked or modified by the method set forth in the trust instrument or by another writing other than a will signed by the settlor, unless the trust provides an exclusive method. In Anderson's case, the trust required amendments to be signed by the settlor and delivered to the trustee. But here's the catch. The interlineations were not signed by Anderson. His trust was like a cake missing its icing. It was incomplete. Now, Day, one of the new beneficiaries, tried to argue that the post-it note served as the missing signature. After all, it was in Anderson's handwriting. He even delivered it and signed the note, best, Rob. Alas, the court said, nice try, but no dice. The post-it note was just a separate writing identifying the enclosed documents. It wasn't a signature accompanying changes to be made to the trust as the trust required. So the moral of the story is, when it comes to amending a trust, a post-it note just won't cut it. Make sure you follow the requirements of the trust and get the amendment signed. Otherwise, you, or more likely your family, might end up with a not-so-funny mess on their hands and a lot of money flying out the door. Click here to check out our previous video, or check out this other great video.